Good morning, everyone, and welcome to the fourth session of our conference. And the theme for this session is strategic litigation in practice. My name is Anya Ryle. I work at the Centre for Law and the Environment at University College Cork in Ireland, and I'm also Vice Chair of the Aarhus Convention Compliance Committee. And because of that role, it's important for me to say that I participate in these proceedings in a purely personal capacity. This session follows on from the very rich discussion we had earlier this morning on the theme of how to promote access rights. And there were some very important themes that came through in that session, including the necessity of providing understandable, available information to the public, the importance of training, including training for the judiciary. And there was also a lot of discussion around specialisation, including specialisation in the context of environmental courts and tribunals. And interestingly as well, for someone like me who is an academic lawyer, the role of the academy in promoting access to justice and in promoting access rights was also raised in quite a number of the contributions. So this particular session, which is the final session of the conference, focuses, as I said, on strategic litigation in practice. And without further ado, then I will move on to introduce our next contributor, Agata Szafraniuk, who works at ClientEarth as a lawyer in the Wildlife and Habitats Protection Programme. And prior to that, Agata worked as a lawyer at the Office of Competition and Consumer Protection in Warsaw. She holds a master's degree in law and a postgraduate qualification in intellectual property rights from Warsaw University. I'm obviously not very good at pronouncing people's names, and with a name like mine, Anya Ryle, I know how difficult it is when people mispronounce your name, and I apologise, Agata, if I have, and I probably have mispronounced your surname, so please forgive me, and I look forward very much to hearing your contribution. Thank you.
Hi, thank you very much. Yes, don't worry. My surname is Agata Szafraniuk, but I imagine it's difficult to pronounce. Yes, so hello everyone from all over the world. As a small reward for you, that you are sitting on a Friday afternoon and listening about litigation from your own will, I would like to take you on a small excursion. And it would have been a 300-hour trip if we would go from Brussels to Białowieża. But let's assume that we reach the goal. After this long walk, we arrive at the famous Białowieża forest in Poland, worldwide known for a higher conservation value, a lot of very old trees, some centuries and even more, and a lot of dead wood in the forest. But let's come back. Let's assume that we are in this forest 3 years before, and if we would be there, this is what we would see mostly. An outbreak of the spruce bark beetle triggered an increased logging in the forest, and this intensified the conflict among different groups of stakeholders: forest manager, conservationists, NGOs, lawmaker, and policymaker. As a ClientEarth, we were at the heart of this conflict, responsible for the legal strategy on behalf of NGO community. But let's deep dive in the case. The forest is divided, it lies on the border between Poland and Belarus. The Belarusian side is protected by 100% by a national park, whilst in Poland this is protected only 1/5 as a national park. The rest is managed by the State Forest Authority. But what is important, of course, the whole Polish part is a Natura 2000 site. Polish authorities decided that forest is under threat because of the outbreak of the bark beetle. The bark beetle is infestating spruces and making them eventually dead. But scientists said that actually the bark beetle is in the era of the rapid climate change is actually a natural factor which shapes the changes in the forest composition. And moreover, the logging will create a lot of danger for the delicate ecosystem. and especially create a danger for this guy, a three-toed woodpecker. As the name suggests, he has only 3 fingers, like the other woodpeckers have 4 of them. And he only can live in the old growth forest with a lot of dead wood and a lot of bark beetles to eat. And also there would be a danger for this lady, a pygmy owl, a tiny owl in Europe, she relies upon woodpeckers to make a nesting hole. And we had a scientific evidence proving that the logging will significantly reduce the availability of breeding sites for those species. And it will also cause significant disturbance during the breeding period. That is why we decided to submit a complaint to the European Commission together with other NGOs. We claim that actually the minister who approved the logging in the Białowieża forest did not determine before whether the logging would have an adverse effect on the Natura 2000 site. And of course, this assessment is known as the appropriate assessment and is required by the Birds and Habitats Directive. We did not bring our own claim on the national level because we did not have standing. Why? Because actually the decisions, okay. Because the decisions which are about the forest management forest in Poland are considered as an internal act, which means that actually the Polish society, neither NGOs have a right to challenge that. But this one, the Polish Ombudsman, the Commissioner for Human Rights, did not like it and actually challenged the environmental decisions in Warsaw Administrative Court. We joined the procedure. However, the court dismissed our claim, saying that actually still the decision about logging has an internal character because the state forest is managing a state treasure, which is the forest. Therefore, the decision has an internal effect and not the external one. What does it mean? It meant that actually 1/4 of the Polish territory is outside of the citizen control. And at that time, already the social mobilization in the forest and around Poland was at the highest peak. There were a lot of protests around the biggest cities in Poland. But also there was protests in the forest, which actually was decided to be closed by the Polish authorities. But despite this, people were organizing walks, lectures, and meetings about conservation in the forest. Also, at that moment, the European Commission started the infringement procedure and fast-tracked it at every stage later. At that time also, the blockades in forests were at the highest peak. First time in the history of this forest, the heavy machinery, the harvesters were entering into the forest, and those machines could kind of cut 200 trees within 1 day. Conflict escalates. Activists chained themselves to the trees or logging equipment, and actually some said that this protest in the forest become a symbol of the reawakening of Polish people Polish disobedience after the communism time. It also happened that Białowieża Forest, I didn't tell that this before, is also a UNESCO World Heritage Site. It's a transboundary site between Poland and Belarus, and it's the only natural site we have in Poland. It happened that during this very intensive time, there was a UNESCO summit organized in Poland, and also Poland was the member of the UNESCO committee. It was the last year of our membership in the committee. It's like the UNESCO has like a committee. It's like 21 countries chosen for 5 years cadency. So Poland has a right to vote on the decisions. And then there was a lot of protests. So imagine how big pressure was then on this event in Poland. There was protests in front of the conference hall. On the one side, there was people who from the forestry who were, and then on the other side of the street, there were people who were actually for the protection of the forest. So imagine kind of the confusion of the people from the UNESCO, from around the world, from Philippines, Zimbabwe, who did actually not have a clue what is actually happening. And probably they saw the first time in their lives such a big interest in the UNESCO event. But we were there in the UNESCO summit, trying to get the committee to make a decision condemning the logging.
And right now, one of the biggest miracles of nature is destroyed with heavy machines, and this has nothing to do with the act of protection.
It was one of the most intense 3 days actually in my life. It was the first time I dealt with such a political reshuffle on the highest international level. And the Polish government, with the help of the Kazakhstan representation, wanted to convince the UNESCO committee that everything is okay at the Białowieża. And we, on the other hand, provided evidence otherwise. In the end, UNESCO urged the Polish authorities to end the logging and warned that if it will not stop, the Białowieża could end up at the World Heritage Sites in danger. We were very, very happy. It gave us hope that actually something can change and the logging can stop. But fortunately, Polish government did not actually listen to UNESCO at all. It has to be also added that not everybody on the ground were so happy with our actions. There was quite a lot of resistance on the local level. People were actually very hostile towards the environmentalists. They were blaming us for destroying the forest. And it's with that, we also had to deal with. At that time, the logging still continues, and from the European Commission, and then for the time, the European Commission started it referred the case to the Court of Justice finally, and with the referring, it also include the request for interim measures. And then court, after a couple of days, agree with the request for the commission and imposed an interim ban on logging. But unfortunately, the Polish authorities did not listen and still continue to logging. They were saying that actually they are doing it for the public safety because there are people in the forest, like mushroom pickers, who can be injured by the fallen trees in the Białowieża forest. In response to that, actually, the European Commission submit a formal request to the Court of Justice to impose financial penalties over the logging, and this request sets a precedent. The Court of Justice agreed with the Commission request and warned Poland that if it will not stop the logging, there will be some very high financial penalties. As a result of this action, finally, the heavy-duty harvesters left the forest.
Właśnie się wycofuje.
It was a very important day for the Polish society. A lot of people were saying they were very grateful for it. And actually all this process showed that even though sometimes we don't have some provisions to stop some actions in European Union law, the European institutions can actually do everything to make the European Union law effective. Later on, we had the opinion of the Advocate General, who confirmed that increased logging breached the European Union nature law. At that time, also in early 2018, the famous minister who approved the logging was dismissed from his position. And then Also, at that time, we lost our case on the national ground regarding the access to justice. Because we, together with the Polish Ombudsman, we appealed to the National Administrative Court, but fortunately it was dismissed. Later on, we submitted a complaint to the Aarhus Convention Committee, and now this case is still ongoing. So then we were waiting as this bison who is roaming freely in Białowieża forest, we were waiting for the Court of Justice ruling. And finally, it came. In April 2018, the judges, the Grand Chamber ruled that increased logging in the Białowieża forest violates European Union law. The courts admitted that the Polish authorities failed to adequately protect rare and precious species in this Asian forest and failed to assess what the impact that the logging could have on the unique ecosystem of this forest. It was a huge victory for all defenders of Białowieża forest. However, in 4 weeks later, after the judgment, which was actually very effectively straightforward, the Polish authorities did nothing to comply with the judgment. That's why we organized a press conference to actually highlight the failure on acting on the Polish minister and actually put the pressure on him to comply with the judgment.
That's why we decided to organize this conference and tell public what is the state of the forest range. Together with us, there is a representative of Greenpeace, WWF, and local grassroots organizations, and there are also scientists.
And actually, 20 minutes after this conference, the minister announced that he will reverse one of the decisions which allowed logging, which was a huge success. But then also there was other ongoing processes still on the ground. As I said before, we had still an open file in front of the UNESCO committee. So the reactive mission of the UNESCO came to the forest and checking, assessing to what extent Poland is implementing recommendation from the UNESCO summit, which was happened last year.
Excuse me, Agata, just if you could finish up in 2 minutes or so, please. Thank you.
Yes, so then of course we had like ongoing other processes. Later on in 2019, there was a fresh threat to the logging in the Białowieża forest. The Polish Minister of Environment announced that they want to restart logging in the Białowieża forest. Fortunately, having a very strong Court of Justice in place, it was much more easier to stop it. And so far, this is not happening. But from my own, just summing up from my own perspective, when I think about this case, and think about the biggest outcome for it, of course, apart from stopping the logging and making all the Polish society aware for the conservation issues, I think it's also giving a hope. And this hope is for a lot of people working on the ground with cases like this, and showing them that actually it can work. And this is one of the examples, because we have been approached by the Romanian NGOs, and this is which is Romania, and the shoot was taken by our partner Agent Green. In Romania, they are having a very similar problem like we did in Białowieża. There is an intensive logging, like deforestation is a systemic problem, and virgin forest is systematically logged, and no national remedies appear to be able to prevent this logging. So they ask us for help, and we use our experience and knowledge gained within the Białowieża forest. And together with the local partners from Romania, we lodged a similar complaint that we lodged in the Białowieża forest to the European Commission last year. And then the data also of the local Romanian organization shows that the area which is imposed to logging is actually 5 times bigger than the Białowieża forest in Poland. The Commission acted very quickly, and already in February this year started the infringement procedure, which was followed up by the reasoned opinion in July this year. And we hope that it will continue, and we hope that with the knowledge we gain And I think what we are doing, we were able to protect another very precious place in Europe, which is virgin forest in Romania. So thank you very much.
Thank you very much, Agata, for that absolutely superb presentation and for the visual effects and the sound effects, which I think were really powerful. And again, it demonstrated so dramatically the threats to our precious habitats, and again, also the importance of protecting environmental defenders. And also, I think you demonstrated very well the potential power of the European Union institutions, including the Court of Justice, the role of interim measures, but again, the importance of people being aware of their rights under European Union law, being aware of the possibilities offered by the Aarhus Convention. And that links back very much to the earlier session this morning about promoting access rights. And I liked the reference you made to hope, because without hope, we have nothing. And it is so important for future generations that we demonstrate the power of the law and how important it is to fight that good fight. So thank you again for that absolutely superb case study. I turn now to our next contributor, and it's my enormous pleasure to introduce Dennis van Berkel. Dennis is legal counsel, as many of you will know, to the Urgenda Foundation in the Netherlands, and is co-director of the Climate Litigation Network, which supports climate cases worldwide. And it's my pleasure now to give the floor to Dennis.
Thank you very much. I hope I won't disappoint anyone, that I won't have any of the immensely fantastic graphics and movies that we had in the last presentation. You'll just have to do with my face for the coming 15 minutes. As said, I will tell you something about the Urgenda case in the Netherlands, and specifically the role that human rights played in that case in the protection against the climate crisis. We started the case in 2013. We started the case together with 886 Dutch residents against the state, and the context of the case was that there was no regulatory framework in place that we felt provided enough protection against climate change. And therefore we argued before the court that the insufficient actions that the Dutch government was taking with regards to climate change were a violation of its general duty of care under Dutch tort law, and were a violation of human rights, particularly Article 2 and Article 8 of the European Convention on Human Rights that protect that right to life and the right to family life. We won the case for the first time in 2015, where the Court of First Instance ruled that indeed the Dutch government was violating its duty of care towards Dutch residents, and ordered the government to reduce its emissions by a minimum of 25% compared to 1990 levels before 2020. The government appealed the judgment all the way to the Supreme Court, and in December of last year, 2019, the Supreme Court ruled in our favor, ruling that indeed the inactions of the Dutch government, or the insufficient action of the Dutch government, was violating the human rights, and upheld the order. Now, I will highlight three elements of that judgment. The first one was standing and access to court. In the first instance judgment, we, as an organization, Urgenda, filed the case together with these 886 residents of the Netherlands. As an organization, we were able to do that because there's a specific provision in the Dutch Civil Code that allows general interest organizations to present these general interests in court cases. This is a specific provision in the Dutch Civil Code, and whether you as an organization have standing in such cases is determined on the basis of your statutes. So if you represent on the basis of your statute, you represent certain interests, and Urgenda, the purpose of Urgenda is to prevent the climate crisis, and therefore we were able to represent the interest of Dutch citizens that were affected or are affected by the climate crisis. The court did not rule on the 886 other plaintiffs, because the court ruled that they no longer had an interest individually in the case, now that the court had already ruled in favor of the foundation Urgenda. The second aspect of the case that I want to highlight is how we used human rights. The court, the Dutch Supreme Court, in its judgment in December of last year, outlined that in the event that there is a real and serious threat to the rights under Article 2 and on Article 8, there is an obligation on the state to take appropriate measures, in short. And in addition to that, it's also an obligation based on the jurisprudence of the court in Strasbourg to substantiate that you are indeed taking sufficient measures in order to prevent the threat from coming into being. The court applied this general case law of the European Court of Justice to the facts of climate change, and it looked at the case law of the court and said, yes, on the basis of the case law of the court, these threats can also be future threats, and they also do not need to be threats to just a small group or particular individuals, but they can involve threats that involve the entire larger population and society. The court then asked, but do these rights also offer protection to these global threats, that is climate change? And the court in brief said, well, if this were merely a national problem, there would be absolutely no doubt that there would be a violation of human rights, and that there would be obligations on the state to act to prevent these threats from coming into being. So the question here is the mere fact that this is a global threat takes away this protection that would otherwise be enjoyed under the ECHR. The court then looked and applied what it called the common ground method, which is a method of interpretation of the Strasbourg court to interpret what the content of the rights under the conventions are in areas where it hasn't decided before. And this common ground method allows the court to look at other sources of law to interpret the concrete obligations. And in this case, what the court did was look at the UN Framework Treaty on Climate Change. It looked at the Paris Agreement. It looked at the no harm principle under international environmental law, and it looked at principles of partial responsibility, both under international private law and national private law. And it came to the conclusion that with regards to the specific obligations of the Dutch state with regards to its human rights obligations, it had to do its part. It had to do its fair share of emission reductions of the total global necessary reductions. The court then came to the next step. What does this mean specifically for the Dutch state? And here, and that's the third element that I would like to highlight of this case, is that here the court was asked, does that really mean that the Dutch state can be ordered to reduce by a specific amount of emission reductions, which was this 25% emission reduction? And the court said, well, in general, if we look at climate change and all policy areas, principally it is for the government and parliament to come up with policies with regards to how much it should be reducing. However, once we establish that there is a certain right and there is a duty to protect on the side of the government and of the state, it cannot be the case that the state can do nothing. In other words, the presence of the right means that there must be some lower level, some lower limit to what constitutes the minimum amount of action that the state has to take in order to protect the rights and to comply with its duty. So the court said it is in fact the duty of a court to look for this lower limit. And one of the reasons why, and it found the reasons for that in general principles with relation to rule of law and constitutional principles in the Dutch context, but also Article 13 of the ECHR, the right to effective protection. The court then assessed, made a factual assessment. It looked at the science, it looked at international climate negotiations, it looked at what the state had said with regards to what it could do and should be doing in the national context, and it came to the conclusion that based on all these facts, that this was really the lower limit of what could be required of the Dutch state, and also that the Dutch state had not substantiated in any way that a lesser emission reduction would actually be sufficient in order to protect the rights. So this was also a very crucial part of the judgment, that is sort of this duty to substantiate that what you're doing is actually sufficient and appropriate. So to sum up, what the Urgenda case has shown first and foremost is that human rights can offer effective protection against the climate crisis, and secondly, that courts play a very important and central role in protecting these rights. And I'm looking forward to the other presentations and questions that might follow.
Thank you very much, Dennis, for that fascinating contribution and for highlighting so many key points that I think sets the scene very well for our subsequent discussion. In particular, the potential of human rights law to offer protection against climate change, and also, of course, the role that organisations like the Urgenda Foundation play in this form of strategic litigation, and the beacon for other organisations that Urgenda and the Urgenda Supreme Court decision in particular has been for litigation right throughout the world, and that you are to be commended for the great work that you have done there. Without further ado, I think it's appropriate then to move to our next contributor. Our next contributor is Lorenz Riedeler, who is a practicing lawyer of 20 years standing based in Vienna, where he is a member of the bar. He has studied in Amsterdam, Graz, Aberdeen and Salzburg. He has served in the scientific staff at the Austrian Constitutional Court and also as a university lecturer in the field of environmental law. And I look forward very much to hearing Lorenz Riedeler's presentation. Thank you.
Hello. Good afternoon here from Vienna. First of all, I would like to thank the organizers very much for giving me the opportunity to make a short contribution at this conference, especially from the perspective of Austria. The topic is really very actual, and that's why I personally think it's a very, very good idea to talk about this in an international context. Finally, the high interest in this conference shows how important and timely this topic is. Yesterday and this morning, I followed the individual sessions a little, and I have to say that I'm really impressed about how many different aspects on the subject in the various countries, and I'm also sure that there's considerable need for scientific and academic activity and research on all of these questions. However, unfortunately, I do not have a video like Agata, but for myself, I thought to present to you a more rather practical approach. And therefore, assume that it is more interesting for you to learn about the day-to-day problems and legal issues environmental organizations face in everyday life. So what are the daily challenges? Will I be informed about the project? Will I have access to information? May I inspect all the files? Do I get this information? The second and more and more coming up question and problem is if I do have the opportunity to take part in the proceedings or even to be able to make technical statements. Am I informed about a public hearing? And finally, environmental organizations sometimes really struggle to have the possibility to have a court decision review. Now, let me tell you something about the legal implementation of the convention, of the Aarhus Convention in Austria. It is still really extremely tough and slow. In 1998, it was signed by the Austrian Republic and ratified in 2005. And then not much really has happened until the year 2017. By that I mean that this convention has not really been applied in practice. And then came the decision on the ECJ on Protect in the year 2017, which hit the Austrian legal landscape quite strongly. This case actually was about the implementation of the Water Framework Directive, and the environmental organization could not take part because it was told that it was too late. It was precluded, and then as the local standard to appeal against the decision to court was needed, party status was needed for that. It was told that it's also not allowed to apply to court. However, the Austrian Administrative Court, it's the Supreme Court here in Austria, then essentially implemented this decision and the requirements early in March 2018. And then it happened like a quick suggestion, and an intensive discussion then came up on this topic in Austria. There were many events and meetings, and also the government started to think about a solution for legislation. In the year 2018, there was the first implementation of the convention in the so-called Agus Participation Act, and it came into force in late 2018. I have to restrict this because the implementation only relates to certain legal areas, in particular to water law and air pollution law. In many other areas of law, implementation has not taken place. However, this is mainly due to the fact that Austria is federally organized, and the legislation of the individual matters, such as nature conservation law, or for instance spatial planning law, is in the exclusive competence of the federal states. So, I was asked to tell you a little bit more about the obstacles. Where can we identify the biggest obstacles now? There's still a considerable backlog in the implementation of the convention into Austrian national law. This applies especially with regard to Article 9, Paragraph 3. Not at least for this. In the last progress report, the Convention Compliance Committee once again asked Austria to take further steps by October this year in order to meet international obligations. In this context, the federal structure of the Austrian Republic also creates more difficulties, as mentioned before. Implementation must therefore be carried out in many different places and in a variety of legal matters. In addition, the legislator is obliged to act, or should act, because following the Austrian legal system, we do not have really legally binding court decisions in the sense of case law, as it is, for instance, like a source of law in England. It is therefore necessary that all the questions, all the detailed problems must be brought to the highest court by way of individual decision in order to obtain a reasonable binding legal opinion. Sometimes, like it was in this Protect case, these proceedings also result in a preliminary ruling. This also means that there are not really many Supreme Court decisions on so many detailed questions, especially with regard to the application of the convention. And sometimes the law is not uniformly applied. Also, again, because of the federal system, the federal administrative courts may apply the law in a different way. Secondly, the situation for the organizations is becoming also more difficult. With an amendment to the relevant law in the year 2018, stricter recognition requirements were created. In order to take part in the proceeding and have party status, they have to prove at least 100 members, and also they have to continuously prove all the criteria to the authorities. And in practice, really a very, very big problem is the financial aspect. Especially the smaller organizations, the private environmental organizations really struggle with financial difficulties, and not just because of the corona crisis. Since all the procedures are becoming more and more complicated, and very often you need technical statements and expertise, it is also required for the NGOs to buy them, to spend high sums on these expertises, and therefore a lot of procedures, or many procedures, at the moment are not affordable anymore. With regard to the implementation of the convention, just a few more points. Where the biggest problems were still the definition of organization to be accepted as a party is regulated differently. And one challenging aspect is also that the applicability of the convention is limited only to questions related to the environmental law of the Union, and the convention is not applied to the environmental provisions of only national law. And the authorities quite like this distinction in their decisions. Also, only certain types of procedures, especially decision procedures, are recognized, and for example, regulations, which also represent environmentally relevant decisions, are recognized. Some laws also regulate that the objections by an environmental organization in the proceedings are not permitted. The rules of preclusion are unclear. There's no uniform transitional provisions in the implementing laws, and there's no uniform regulation for the so-called retroactive period. Briefly, let me tell you a little bit more about this period. After this protect decision, it was not clear how far back the right of an environmental organization went to contest environmental decisions. Unfortunately, there are still different opinions and different requirements in all the individual implementation acts. However, the Austrian Administrative Court, which is the Supreme Court, dealt with these questions in a decision from 2019. It came to the conclusion that the corresponding retroactive effect can extend until the year 2009. The court argued that it's not necessarily depending on the entry into force of the convention in the year 2005 and not on the protect case in the year 2017. Rather, it depends on the time the Charter of Fundamental Rights came into force, which is in the year 2009. This because the court argues that the convention finds its real effects only in connection with Article 47 of the Charter. Now, yes, as already described, impacts, the net is becoming closer, and the legal status and the possibilities for environmental organizations are defined more and more in detail, so it's improving the system, and we do have many different individual decisions. In any case, I may state positively that the entire process makes the procedure more transparent and can therefore be perceived much more strongly also by the public concern. So the public awareness is much better now. Looking at the way forward, just to sum up, there's also good news. If the authority answers the question of the potential significance of effects of an environment under Article 6, paragraph 1b, positively, the environmental organization must be involved as a party via Article 9, paragraph 2. Consequently, it must have local standing to appeal to court against this decision. So far, it's clear. However, our session 4 now is titled Strategic Litigation in Practice. In any case, from practical experience, I can report that in this ongoing process, it is often easier to assign the individual questions to appropriate authorized persons. I sometimes call it party management. So, for instance, landowners or neighbors can usually bring forward other subjective rights than, for instance, environmental organizations. However, if this Article 6, paragraph 1b is not to be used, and the authorities initially rule out significant effects on the environment, we do have a diverse range of decisions. The most important thing is still the opportunity to have access to information, to participate to the proceedings, and to strive for judicial review against the decision. I personally would have liked to see a real status as a party in all procedures for environmental organizations in the implementation. However, unfortunately, that's not the case so far. Finally, I personally also think that a full party status, and not only a status as participant, also serves the interest of a project applicant. In order to obtain quickly clarity about the admissibility of the application and not to be exposed to the risk that the permit, once granted, will subsequently be challenged by an environmental organization that has not previously been involved for reasons unknown so far. Right, time is up. So this is my first brief assessment from the Austrian point of view. Thank you very much for your interest, and further questions are welcome, and thank you very much.
Thank you very much indeed, Lorenz, for that excellent presentation. And indeed, it provided us with a very clear and very sharply focused case study of the position in Austria. But you also provided some very important overviews as regards the need, as you put it, for scientific activity and for research on the wider issues around access to justice. I liked also the way that you highlighted the significance of the Protect judgment and how the implications of that judgment, you're pushing the frontiers of access to justice. There's still a lot to be teased out there. And I think that by referring so well and in such detail to the various obstacles that allegedly arise within the Austrian system, it demonstrates the very diverse approaches that different state parties take to access to justice, and the different variation in rules governing NGO standing, for example, that you see right across the state parties who have signed up and ratified the Aarhus Convention. I won't say any more on that, obviously, because the Austrian scenario is a live issue before the Compliance Committee, but in general terms, there are issues there that need to be teased out in very many jurisdictions, and especially issues around criteria for standing and for party status for environmental NGOs. So thank you for raising those issues and for raising them so eloquently. We move then to the final contributor in this particular session, and it's my very great pleasure to introduce Andrew Jackson. I must say I've known Andrew for a significant number of years. He is a wonderful colleague and a superb lawyer. He is Assistant Professor of Environmental Law at University College Dublin and also a solicitor with the firm O'Connell and Clark. Andrew has litigated public interest environmental cases for many years now, including before the Irish, English and European Union courts. And he states very modestly in the short biography that he has provided for the conference that he recently acted in Climate Case Ireland. But I can say as a statement of fact that Andrew's role in that case was absolutely pivotal, and he has been and continues to be an inspiration, not just in Ireland, but I think at this stage globally. And I'm looking forward very much to what he has to say around Climate Case Ireland and strategic litigation issues more generally. Thank you, Andrew, and we're delighted to have you here this afternoon.
Thanks, Anya. Thanks for the very kind introduction. I'll just wait until my slides appear on the screen here. Here they are. So I'm going to talk about the case known as Climate Case Ireland, which was a case taken by Friends of the Irish Environment, a small NGO against the Government of Ireland, ending in the Supreme Court of Ireland in the summer this year. By way of background and context to the case, we have to turn the clock back to 2017 when the case started. Now, at this time, Ireland was doing very badly in terms of its performance on climate change. We had the third highest greenhouse gas emissions per capita in the EU. Ireland's emissions were projected to rise by about 10% between 1990 and 2020, and not to fall by the 25 to 40% range, as was advised at that time by the IPCC and as the Irish government had explicitly endorsed as being necessary. In addition to this, the Irish government was perceived at this time, at least amongst the environmentalist community, to be playing a negative role on the international stage at EU level in terms of 2030 ambition and so on. So all of these factors combined led to the thought, well, how could we change this narrative? and how could the law potentially be used to change this narrative. The opportunity arose with Ireland adopting its first framework climate law in 2015, the Climate Act 2015, under which the government had to adopt a national mitigation plan every 5 years, as the name suggests, setting out what the government planned to do for the next 5 years in the field of mitigation. The first plan emerged in early 2017 and was finally adopted over the summer. It was, it's fair to say, very weak. It was vague, it was aspirational, and crucially, as it turned out, it wasn't a mitigation plan at all, because over the 5-year life of the plan, 2017 to 2022, Ireland's emissions were projected to increase, not decrease. So we had about 3 months to put together our legal challenge from the date of adoption of this plan in July 2017, which is a relatively short period, as you can imagine. We did that and commenced the case in October 2017, ending in a High Court judgment in September 2019, and then the Supreme Court judgment, as I mentioned, over the summer in July this year. In terms of the nature of the case, it's an administrative law challenge to the 2017 National Mitigation Plan, and it was really in 3 major parts, so there were 3 groups of arguments. The first was that the making of the plan didn't comply with the Climate Act in various ways. We argued that it excluded certain mandatory elements and that the government did not properly have regard to listed factors, for example, climate justice, the Paris Agreement, and so on, in making its plan. The second group is related to Ireland's constitution, the allegation here being that in making a mitigation plan that allowed for emissions to continue rising in circumstances where the Irish government had explicitly endorsed the science of the IPCC, suggesting that emissions needed to fall deeply and rapidly, that the government had breached various rights under the Constitution, including the right to life, the right to bodily integrity, and the so-called unenumerated or unwritten right to an environment. Now, when this case launched, when Climate Case Ireland launched, no such right had been recognised in Ireland, but Friends of the Irish Environment was involved in other ongoing litigation in which that unenumerated right to an environment was being argued. And then the third group of arguments related to the European Convention. And like in the Urgenda case, we argued that there was an infringement of the right to life and an infringement of the right to respect for private and family life and home. Again, when this case started in October 2017, we had the Urgenda judgment at first instance, but there had not yet been a finding of a direct breach of the ECHR. But we knew that Urgenda was appealing that point to the Court of Appeal, and so that position might change. And we also had the thought, well, even if that appeal is not successful on that point, maybe we'll get a different outcome in the Irish courts if we argue the same point. Now, it's important to say the case was directly inspired by the Urgenda litigation, and it was built, as was the Urgenda case, very deliberately on the science of the IPCC and on other authoritative, effectively uncontestable sources, meaning that we could go into court and not argue about the science or the evidence, but rather say, here is the agreed science and impacts, now what are the legal consequences that flow from this? After the case launched in 2017, there were 2 important legal developments that gave increased prominence to the rights aspects of the case, in other words, to the constitutional and ECHR aspects of the case. The first was the judgment in the Dublin Airport case, just a month after Climate Case Ireland started. This was a separate legal action taken by Friends of the Irish Environment, challenging Dublin Airport's permission to build a new runway. And the substantive challenge was not successful in the sense that the permission for the runway was not quashed, but the High Court went for one of Friends of the Irish Environment's arguments, namely that there is an unenumerated right to an environment consistent with human dignity to be read into Ireland's constitution. And you can see the text in green there. And that was, landmark groundbreaking, widely welcomed in the environmental community. But the Irish government didn't accept that this was a binding finding of the High Court and continued to argue via the Climate Case Ireland proceedings that rather that finding was obiter dictum and that no such right can be properly read into the Irish Constitution. The second important development that gave greater prominence to the rights arguments was the Court of Appeal's decision in the Urgenda case, finding, in contrast to the finding of the District Court, a direct breach of the ECHR. And that elevated the significance of the Urgenda case for our own proceedings from an inspiration to potentially something that was of much greater direct precedential value, as is the case, of course, for other countries that are party to the ECHR. Now, a question that we faced was how to present the science in Climate Ireland, because we felt that the facts were very much on our side. And in fact, the factual matrix was worse for the Irish government than it was for the Dutch government in Urgenda, because in Urgenda, the Dutch government was reducing its emissions, but not by enough, whereas in Ireland, emissions were continuing to rise. So we tried to operate on the basis of two central principles: present the science as clearly as we could, and we did that by way of a strong, uncontested narrative in our written submissions, and we pared down the scientific evidence to a single lever arch file of key excerpts from the exhibits, supported by about 20 colour images that we blew up to A3 size, so that counsel could talk the judge in the High Court and then the Supreme Court through the climate science and impacts. And the second principle was to present the science in a way that would resonate with and align with the Urgenda judgments, because we needed, to the extent we wanted to rely on Urgenda as a precedent, we needed the judges to understand, well, where do these figures come from? What's 25 to 40%? Why did the Urgenda courts order a reduction of at least 25% and so on? So we had to put the science before the court and do that as clearly as we could. But here's the first interesting access to justice point. In the Irish government's very first response in this litigation, which was February 2018, they took a very aggressive position on costs, in which they said, and there's sort of two parts to this. First, you've exhibited a lot of material, a very large number of documents, often voluminous in nature, totaling 2,500 pages in total, have been exhibited, despite the fact you're not seeking findings of fact to be made, and there's been a failure allegedly to identify their relevance to the case. And it's been necessary for the government to spend a very significant amount of time and incur considerable expense considering these documents, despite their alleged lack of relevance to the case. And then the second point they made was, in failing to allegedly to properly identify and particularize your case, you've caused prejudice to the government, necessitated much more complex and costly pleadings in response, and required the court to expend unnecessary additional time determining the case. And they said the government will seek the costs incurred by your prolix pleadings, regardless of the outcome of these proceedings. If the special cost rules for environmental cases pursuant to the Aarhus Convention are deemed to apply, the court may nevertheless award costs against a party if appropriate, because of the manner in which the party has conducted the proceedings. Accordingly, the government will seek an order for costs occasioned by your prolix and excessive pleadings. Now, I was struck reading this last night, and knew as I went to find the text to put into the slides, you might be surprised reading this to learn that the government went on to lose this case, because looking at this, you would think that we had a hopeless case and that we'd presented it very poorly. We replied by saying, the Aarhus Convention covers prohibitive expense. It also covers how you treat litigants. Litigants must not be penalized, persecuted, or harassed for exercising their rights. That doesn't stop the awarding of reasonable costs, but I would put it to you that it's ill-advised, I think, on the government's part to refer to the considerable expense that they had incurred and so on in putting together their defence. So you can see from the outside the government's response was, was very aggressive on this point, which goes to access to justice. We put a lot of thought into the campaign side of the case too, with the advice of Dennis and others from Urgenda. And I'll just flick through. This goes to my points on standing in a moment, which is the final point I'll make. We started, it was a very small grassroots campaign at the start with very small numbers of people coming to court. But it built up over time, and we had some support from small grants from Patagonia for campaign hours, and they decorated their shop window in Dublin in support of the case and held various events in-house. We had a great website for the case and gathered more than 20,000 signatures in support by the time we were in court. And that led to an extraordinary experience in the High Court in June 2019. And this is a quote from the final day from the head of the Green Party, who's now our Climate Action Minister, saying, "I've never seen anything like it. Babies and toddlers, young and old, spread politely on the court floor, wrapped in attention to the proceedings. It would make you proud of our republic." And it really would. It was an amazing and very moving experience to hear fundamental rights being aired in front of the entire community, including babies and toddlers. There was one baby there for all 4 days of the proceedings, crawling around on the floor and making little noises in the background. So really an extraordinary experience that speaks to the public interest in the case. When the High Court's judgment came, it was disappointing. And we got permission to leapfrog directly to the Supreme Court. And here we are arriving in June this year during the pandemic, of course. The hearing had to be held in a special room to accommodate the 7 judges and the legal teams in terms of social distancing. The judgment came just 1 month after the hearing, which was quite amazing in itself. A unanimous judgment delivered by the Chief Justice saying, well, we won on the basis that the plan falls well short of the requirements of the Act, the Climate Act, so it had to be quashed, in a judgment strongly emphasising the importance of public participation in the creation of climate policy, saying that the public needs to know in detail precisely how the government proposes to avoid dangerous climate change, essentially out to 2050. And also, which is unusual in the Irish context, emphasising that the judges, the Supreme Court, had carried out a substantive review of the plan. And that's clear from the judgment where they refer to reading the detail and saying, well, look, this is vague and aspirational and so on. The other 2 points that are of interest, so in terms of the rights aspects of the case, the court said as a corporate body, Friends of the Irish Environment did not enjoy standing to litigate the personal rights raised in the case. And the Chief Justice went on to say that there is no unenumerated or derived constitutional right to a healthy environment in the Constitution, on the basis that it's either superfluous if it's derived from rights higher in the hierarchy, or it's excessively vague. Now, I wanted to say, this is my last point about standing, because I know that this conference is particularly interested in that as an aspect of access to justice. 2 points to note. First, Friends of the Irish Environment had been held to have standing to vindicate rights, both in 2017 in the Dublin Airport case and in the High Court in the climate case itself, on the basis of its interests. So I think it's fair to say we didn't expect to lose on standing as regards rights. But after the High Court hearing, an unhelpful, from our perspective, Supreme Court judgment was handed down in a case called Simpson. The second thing to say is standing wasn't the only hurdle for our European Convention claims. There's also domestic case law, which arguably, and the state did argue this, was to the effect that the domestic court should wait for a judgment from the European Court of Human Rights on Strasbourg on climate change and human rights, and should not rule before that. 2 points occur to me in terms of standing before I say something about Aarhus. There's a certain artificiality to me about the finding as regards corporate bodies. This was a case about and for people. Witness the extraordinary scenes in the High Court. And it really struck me, setting the law to one side, why insist that we have to have an individual before the court risking bankruptcy to air fundamental rights? And And why couldn't Friends of the Irish Environment have been considered as falling within one of the exceptions to the bar on corporate litigants raising personal rights? For example, why wasn't Friends of the Irish Environment an appropriate litigant to raise the rights of future generations? Who would be better placed to do that? And this is my very final point. If we look to Aarhus, there are interesting decisions in this field. We argued Articles 9.2 and 3 in the alternative. We said we're in either or both. If you look to 9.3, here's a decision of the Compliance Committee in the context of the EU saying parties aren't obliged to establish an actio popularis, but they can't introduce or maintain such strict criteria that they effectively bar all or almost all environmental organizations from challenging acts or omissions and so on. Now, in response to that, you might say we weren't barred because we were able to challenge on one ground. We just weren't able to raise the arguments that we wanted. And the second paragraph of the quote here, I think, is relevant there, says, the criteria laid down should be such so that access to a review procedure is the presumption and not the exception. One way to avoid actio popularis, it would be to set some sort of criteria like the party had to be affected or have an interest. But this presupposes that such criteria do not bar effective remedies for members of the public. And I think there's an argument here, at least, that Ireland's standing rules operate as a bar to an effective remedy in combination with the problem of prohibitive expense. Now, if we were in the field of, if we're arguing about 9.3, no doubt the government would try to argue that the Constitution and rights under the ECHR do not amount to national law relating to the environment. But if we look to the Aarhus implementation guide, it says the decisive issue is if the provision in question somehow relates to the environment. So I think we would have a decent shot on that basis. And the other argument I'd make is that there are parallels, I think, with the position on prior participation, where in general, it's not permissible to restrict an NGO in court to the arguments it raised during the administrative procedure. And I would say, well, why then should it be permissible to restrict the arguments that a corporate litigant can raise on this basis? So that's all I have, and I don't want to finish on a sort of negative note to do with standing, as it were, simply to say the message from the case, I think, is that governments can and will be held accountable for their obligations, their climate obligations and their human rights obligations. And I hope really that this case inspires others just as the Urgenda case inspired us. Thank you very much.
Thank you very much indeed, Andrew, for that, as ever, superb presentation, which not only took us through the detail of Climate Case Ireland, a phenomenal victory for Friends of the Irish Environment, and also something that has inspired, I think, many lawyers, and indeed, hopefully the next generation of lawyers, about the power of strategic litigation to bring about real change that resonates right across society. And I think, as well as giving that account of Climate Case Ireland, you identified an entire range of issues and provided a range of insights into how strategic litigation operates in the practical sense, and the importance, as you put it, in the Climate Case Ireland scenario, of the associated sustained media campaign and the power of social media in particular, getting the message out and encouraging, again, others who might not typically become involved to get behind this particular case. And I know for a fact from my own students how engaged they were through those social media social media campaigns. I think important as well that you mentioned the standing issue, the cost issue, and how the Urgenda case influenced the evolution of the arguments presented in Climate Case Ireland. And also, of course, to flag that in the Irish context, as well as the European Convention on Human Rights, we do, of course, have our own domestic constitutional law architecture, which I think, as you indicated, and as the Supreme Court of Ireland indicated, there is potential to be mined there in terms of moving things forward, hopefully into the future. So thank you very much for that contribution. Now, we turn then to the question, answer and discussion session. And happily, we have a good half hour to do this, thanks to all contributors sticking to time. I'm going to do my best to work through the questions and to group them where they overlap to some extent. And the first question, you have very kindly provided a written answer to this question, but I think it's an important one for all the contributors. So if you don't mind, Agatha, and you can answer as appropriate, it may be controversial, so use your discretion, of course. In Poland, do the judges use standing issues as a means to avoid addressing the merit of a judicial case? Or on the contrary, do they make broad interpretations of legal dispositions on standing? And again, conscious there may be live cases, so this may be an issue on which you are restricted, but if you have any general thoughts, please feel free to comment if you wish.
Yeah, I think it's changing. Actually, just a couple of times in the last couple of years, actually, the Polish administrative courts just mentioned Aarhus Convention for the first time in their judges, in their reasoning. So I think it's a big step. And the issue of standing is changing. Before it was, I think it was really narrow conception by the Polish judges. And now in terms of, and now with the growing awareness of the Polish society, and the kind of the pressure, I think that the judges are making kind of new approaches, and I think it's also because of that they are more aware of the instruments like the Aarhus Convention. I think just it was not the Polish judges were not aware before, like a couple of years ago, and now I think more and more people are getting knowledge about it, so it's changing. And so yeah, that's my opinion about that.
No, I think that's very interesting, and it comes back to the point that was raised earlier when Jerzy Jędruska was here with us, a very excellent question as to whether Jerzy, speaking in a personal capacity, had witnessed or seen an evolution in the way the Aarhus Convention is becoming embedded more and more in the domestic procedures of the state parties. And I think that does resonate with what you're saying too. It takes time, but gradually even EU law and Aarhus Convention law do ultimately become embedded, but it tends to be a long process. Thank you very much, Agatha, for that.
And I have, just have to add that I think it's also a result of the great job of ClientEarth, because my colleagues from the environmental democracy team they're doing great work for the last couple of years in Poland, training judges, making a lot of interesting documents which are available for judges. So I think, I hope it's also because of ClientEarth effort, so yes.
No, and I'm glad that you've raised that point. And again, certainly, as well as ClientEarth, I see myself, many NGOs and other groups right across the European Union and beyond, throughout the states that are parties to the Aarhus Convention, more and more effort at judicial training, more and more effort to promote the rights that we spoke about this morning, and that specialisation that Luke Larverson spoke to so eloquently earlier this morning as well. So I like these connections between the different sessions of the conference and the themes overlapping. So conscious of time and having a big list of questions in front of me, I move now, if I may, to Dennis. Dennis, this question is, I'll just call out the question. I realise that the claim, I guess the claim in Urgenda, I realise that the claim was based on tort law and therefore ended up in the Supreme Court. Can you think if it could have been decided in the Supreme Administrative Court if the case had been based on public law legislation? And myself being totally ignorant of Dutch law, I leave it to you to interpret the question and to share your thoughts. Thank you.
Yes, thank you. This really goes into the nitty-gritty sort of Dutch procedural law things, but in general, you can only go to an administrative court if there's a decision that can be appealed. And there was a total absence of climate legislation in the Netherlands. Apologies about that. So there was no decision that could be appealed. Now there is a Climate Act, but there is probably very little scope in the context of that Climate Act for a decision to be appealed. So the short answer is that it's most likely that even a future case would still end up at the Dutch Supreme Court.
No, I think that's very interesting and something I had wondered about myself. It always depends on what your own jurisdictional background is, but that's an excellent answer, which I think explains it very well. Now, turning to some other questions, and this is a question for Andrew. Andrew, would you care to expand on what we are seeing now in Ireland as the legislative response to Climate Case Ireland, and indeed probably environmental strategic litigation in general in the new climate bill being advanced right now in Ireland?
Sure, thanks for the question. Just to fill those in who are not from Ireland, I suppose, the Irish government now has the Green Party in coalition, and they promised the new government to introduce amendments to the Climate Act that I talked about in my presentation within the first 100 days of government, and they've just done that within the last few days, essentially. And I don't want to go into much detail, really, except to say that the climate bill has disappointed, I think, many environmental lawyers on the basis that it is not yet strong enough to provide an effective framework to ensure that Ireland reduces its emissions in accordance with the science. So hopefully it will be strengthened before it's finally adopted. On the specific point about Climate Case Ireland judgment, the government's proposing to remove and replace the provision on the basis of which Friends of the Irish Environment was successful. And that language was wording to the effect that the government had to specify the manner in which it was proposing to achieve the 2050 objectives that the government had set itself. That wording is being removed and replaced with identical wording in respect of a new, more ambitious 2050 objective. So on its face, you might say, well, that looks okay. They've preserved that language. I'm slightly wary because they have supplemented the relevant part of the Act by a new subsection. So in which they set out some of the content of the long-term strategy that will replace the concept of the National Mitigation Plan that we successfully overturned. And my slight wariness would be to say, well, the Supreme Court is quite clear about what a National Mitigation Plan had to do, what had to be in it, and in terms of meeting the terms of the Act. The proposed revisions now say that the successor plan, this long-term strategy, may include, and then it sets out 3 elements. And my slight wariness is whether it might subsequently be argued in the future, if there was a challenge to one of these strategies, that the law has moved on. The Supreme Court judgment is relevant insofar as it goes, but now the legislature has said these are the 3 things that one of these long-term plans may include. And so that's a fairly detailed technical answer, I suppose. And on the broader question of strategic litigation, the outgoing government at the end of last year, as you know, Atracta, who posed the question, proposed to change the access to justice rules on standing and costs, such as to restrict access to justice. But those changes were not implemented before the general election. The new government has committed to introduce a planning and environmental court, and at the same time review and reform the judicial review system whilst respecting the Aarhus Convention, the programme for government says. And so we'll have to watch very closely to ensure that any changes do respect the Aarhus Convention.
Okay, thank you very much for that. There was a lot to it, but I think you dealt with it very well. I'm going to now just read into the record, as they said, a comment rather than a question, which I think demonstrates the importance and the significance of this particular conference. And the comment is this: in countries with very low litigation rates due to traditional public opinion against cost and the length of court procedures, raising awareness of the legal community to fight against that vicious circle is inspired by dissemination of information on famous cases held in countries with better litigation rates. That's the comment, and I take that perhaps to mean that the references here to the litigation, the strategic litigation that we've talked about and the various cases that have been mentioned during this session might encourage strategic litigation in other jurisdictions where there has so far not been an appetite for that kind of litigation due, as the commentator says, to traditionally low litigation rates and concerns about cost and lengthy proceedings. So that's a strong endorsement, I think, of conferences like this one. And then coming back, if I may, to you, Dennis, a question, and again, you can choose to answer it as you wish, depending on what's appropriate. Would a Dutch judge be concerned, or would a Dutch judge have the power to investigate if an NGO could have been registered ad hoc just with the sole purpose of filing a particular judicial claim, is the question.
Yeah, I think it's a good question, and if you look at the case law of the article on which we base the case, is Book 3, Article 305A. The association needs to not only have in its statutes the purpose of promoting a certain interest, but it needs to have taken active steps in order to promote that interest. So that might be a factor that a court could look at. If you just have an association founded and haven't done any actual steps, whatever those might be, there might be arguments and discussions what those steps and those factual steps might be, but that might be a factor that the court takes into account whether or not it grants standing to that particular organization.
Thank you very much, Dennis. I think that's a very helpful answer, and that was a very good question, and it's something that tends to come up quite a bit in the context of standing for NGOs and the rationale behind establishing NGOs, and there's a lot to be discussed there, and it's certainly something that needs to be considered very carefully for all sorts of reasons. So another question then for you, Andrew, and again, this is very much coming from an Irish perspective. So again, it may be necessary to give a little context, but conscious of time, hopefully a brief answer may suffice. So for Andrew, do you think that the Irish Supreme Court is saying that there may be a right to a healthy environment as part of the right to life? Now, this would be under the Irish Constitution, obviously, rather than the court saying that there is no right to environment at all.
Thanks for the question, Alan. Yeah, well, I think that's a very nice way of putting it, and it would certainly be a nice argument to make, to say that, you know, the right to an environment is subsumed within the right to life, which is, I mean, that's one interpretation of what they said, certainly, that to the extent that the right to an environment doesn't extend broader than the right from which that right to an environment is derived, well, then they said it's superfluous. So you could turn it around as you have and say, well, then it must be part of the right to life. I mean, that would, of course, make the right to an environment very anthropocentric in nature, but that is that would be the nature of a constitutional right derived from one of these personal rights, and it was the nature of the right identified by the High Court, you know, a right to an environment consistent with human dignity. But the court, I think, I will make this brief, the court gave a clear steer, I think, that they felt a bit uncomfortable with the idea of finding such a derived or unenumerated right, and indicated that it might be appropriate to pursue such a right via a popular referendum or something like that outside of court.
Thank you, Andrew, and thank you, Alan, for the question. And just for participants, I'm conscious that there are quite a few questions coming through from Irish participants, and it's not that I'm prioritising those, they just outnumber a lot of the other questions. And there's obviously a strong interest because Climate Case Ireland is so recent and has a wider resonance. And turning then to just some comments that I'm picking up on and drawing on from the chat, because they are important. The position of environmental defenders in particular, and again, I don't mention any specific examples, but again, the concerns about people who are genuinely doing their best to upkeep the state of law, and to protect basic rights. And again, the threat that is there because of the times that we live in, and the necessity of making people aware of the protections that are there for environmental defenders, and ensuring that as lawyers that we step up and protect those rights as best we can. And again, I'm beginning to comment myself now, which is probably never a good thing as chair. But what I'd like to do at this stage, because I'm conscious of time, is to say, and again, there's no obligation, if there is anybody online from the perspective of the European Commission, and there may not be, but I'd like to give anybody from the Commission who might want to make some comments or remarks in light of the discussion, the questions, to feel free to do so if you wish. And you can just simply send something to me on the chat. But again, there's no obligation whatsoever. I'm just trying to widen out the discussion as best we can. And we've already had a lot of engagement through the chat. And while we're just waiting to see if anybody wants to come in, a question to Lorenz. Austria seems to generate many Court of Justice references on standing, protect, Gruber, Burgenland, the nitrate case. Do you see, Lorenz, growing realization from the government that something needs to be done? Or do you think each expansion will have to come from a court of judgment case?
Yeah, thank you for the questions. I personally think that that the government really now is willing to act and to go forward. But these cases, you're right. All of them are about party status, the modalities under which, or circumstances under which the standing is possible, the requirements for the organization. So this is, I think, very typical, and so some kind of Austrian court tradition or decisions tradition is to decide rather formally than in the merits. It's always easier for the judges to give a reason. So in the party status is ideal for this formal answer.
Yes, thank you, Lorenz. I think that's a really good question, and again, your answer is a sensible one. And I suppose it demonstrates too that the law will continue to evolve as new issues come up, and as individuals and NGOs continue to use litigation to push the boundaries to further develop environmental rights. And again, I think we are no doubt going to see more strategic litigation, certainly around climate and biodiversity, and that human rights will likely play a much more significant role in that context. And I suppose it's also probably no harm for me to mention at this stage, and I mentioned this in the keynote address that I was supposed to give yesterday, but which is now up as a recording as part of the conference proceedings, just to remind everybody that the Aarhus Convention Compliance Committee has published a statement on the application of the convention in the context of the COVID-19 pandemic and in the post-economic recovery. And we emphasize unambiguously that the convention rights continue to apply, and that we are watching closely to ensure that that is the case. And I'd refer you as a reference point to our public statement that may well prove useful in a national context. And that's what it's intended to be, a statement of what the position is insofar as the convention rights continuing to apply. So looking then through the various items on the chat, again, just to highlight a lot of concern around the rights of environmental defenders, and concerns about the rise of populism and reactions then and impacts on human rights more generally, and also comments about the Aarhus Convention making it easier in certain cases for individual litigants to bring actions. NGOs obviously have greater capacity, but the power of the convention to also support individual litigants to move to protect the environment. So I don't see any more, let me see. Adam from the Commission has provided a link to the communication there on improving access to justice. I think there was a request for that earlier, so you can find that link in the chat. And thank you, Adam, for providing that. It's very helpful. And I think at this stage, what I might do is just begin to wrap up, and I suppose to call on Anis, who is the main organizer, the main brains behind this particular conference. But first of all, just to say, having participated today and unfortunately having missed yesterday, I found today really informative. I've learned a lot myself. It's great to see the impact that the Aarhus Convention is having and how it's triggering litigation and hopefully ultimately leading to better quality environmental protection and hopefully to providing protection for environmental defenders. So what I will do is to turn to Anis, if she can come online and close the proceedings formally. And I thank you all, our contributors, and I thank you, the participants, for your excellent questions and also for being so engaged during the chat. Thank you, and over to you, Anis.
Thank you, Anye. Can you hear me well? Yeah.
Yes. Yes.
Thank you. Just a sentence of conclusion, and then I need to thank a lot of people. I think it's clear with this conference that it clearly showed that environmental NGOs make the Aarhus Convention, but not only the Aarhus Convention, environmental legislation and actually the law more generally alive, and prevent all these legal instruments from just remaining dead letters and not correctly implemented and enforced. And we see that also with all the recent legislative development, whether it is at EU level with the adoption of the European Green Deal, which has also been adopted thanks to the public pressure, whether it is from the environmental NGOs, civil society organization, young people demonstrating in the streets. It's a collective achievement, I think, that needs to be recognized, but also the revision of the Aarhus regulation that was long awaited and that we are welcome, and that we very happy that it finally sees the light, even if it needs to be improved, and that we hope is going to be the case through the legislative processes before the European Parliament and the Council. But we also see that with all the cases that are being brought by the environmental NGO community at national level, at EU level, at international level, and that are being won more and more. And so we clearly see that this environmental NGO community is playing a key role, really, in ensuring a better implementation, a better enforcement of the law, of environmental law, and contribute greatly to a better protection of an environment. And so really, I think that the ending word to this conference should be hope, because these cases, indeed, as Agata said, give us hope. And even more than the cases that are being won in front of this court, thanks to these environmental NGOs and this community, because I think we are really a community, it's also the great people that work in these environmental NGOs, not only the lawyers that represent them as well, of course, because without them, we often couldn't bring these cases. And the great people, they are also working within public authorities and European institutions, and who make also contribute to this progress that we see happening. So now I really need to thank all the speakers for accepting our invitation to speak at this conference. I really would like to express my sincere gratitude to all of them, and for making such interesting and insightful presentations and thought-provoking, and which gives us hope again. Thank you to Anye, really, for being a great chair and for giving a great keynote speech that you are all able to see now in the proceedings to this conference. Apologies again for the problem with the internet connection and the technicalities. Thank you, Anye, once again. one. I'd like also to thank the European Commission for funding us, and through the LIFE program for funding our Access to Justice project, within which that conference is part of, and for enabling us to really giving all these trainings throughout these 8 countries within the EU, and also all the material that, by the way, you can find on our website. Thank you to Justice and Environment, our partner in crime for so many years, working on ARIS issues and ensuring a better implementation and enforcement of the convention. Special thanks to Shabakis for being such a great coordinator of the project. Finally, thank you to our great environmental democracy team. You just rock. And last but not least, thank you to Capucine, without whom this conference would not have happened, and we would not be talking all together today and being so calm in dealing with all the technical and internet issues we had to face. Thanks a lot, Capucine, for helping me organizing this conference. And finally, thank you to all the participants. We had an amazing turnout with more than around 200 people. So thank you so much for being all here today, and to listen to what I think was a great, great conference. Thanks to all the great speakers. Thank you so much.